business. Case of, if you're present on that case, please approach. If you're present on that case, please approach the podium. Thank you. Your name, sir?
Michael Ubelacker.
Okay, thank you, sir. The way this works is the county officers will testify first, and then you'll be able to respond in any manner that you deem appropriate. So just ask that you be patient. If no one interrupt them, they won't interrupt you, okay?
No problem.
Thank you. All right, county ready to proceed?
Officer Leonard.
Rhonda Leonard, Certified Code Enforcement Officer, Charlotte County. This case was before you on September 7th for junk conditions, abandoned vehicles, and some minor, well, not so minor, International Property Maintenance Code violations. This is a one-day fine for follow-up inspection on October 10th, where there was outside storage, there was an inoperative vehicle, another unlicensed vehicle in the front yard, and the housing code violations had still not been corrected.
Anything further from the county?
Nothing further.
Okay. Yes, sir. Would you tell me what your relationship is to Home Savers?
I am an owner.
Okay. You're up.
I just was showing up to see how this went. Everything is under control now. The back parts where the junk conditions are, there is a permit in effect right now, and we have that being handled. So.
All right. We appreciate your cooperation with this. This is for a past violation.
No, I understand.
$110 fine. Since I don't hear any evidence to refute that it didn't exist, I'll have to sustain that affidavit.
Yes, sir.
And if you just take care of that at your convenience, and if you need some assistance, the staff will help you.
No problem.
Okay, thank you. Have a good morning. We'll take us to agenda case 16, COD 153061, Louise Little. If you're here on that case, if you'd please approach the podium.
My name is Donald Adam. I'm Louise Little's son. I'm here talking for her. She has hearing and voice issues. She cannot speak to you as I can.
Sure.
Now,
Your last
I'm
name,
requesting that, I'm sorry?
Your last name?
Daubenmeyer. I'm requesting you do not stop, or you please stop the video for a second, or the presentation, please.
Well, I don't know that I can do that, but
I have not been able to review any of the pictures. I have not been able to review the case itself after repeated requests for information regarding what violation I'm up against now. There has been no answers for me. I asked this lady this morning if I could see the copy of at least a file of it, and I was asked to be considerate because she had a lot of things to do. Okay, I understand that, but what I don't understand is I'm trying to comply with the county. I'm trying to do the best I can with what's going on. But for me to have an argument at this point, how can I argue what I don't know about?
I have no problem with that. Why don't we just go ahead and continue his case to the end, and then if he needs to see the affidavit, we can let him take a look at it. And
Yes, Your Honor.
just remind me to recall that case.
Your Honor, I'm not a lawyer. How am I supposed to be able to look at this and perform at a good argument in a hour period?
Well, unfortunately, I can't help you there. You obviously had notice of today's hearing. You had plenty of time to get an attorney. Best I can do for you to accommodate you, sir, is I want this process to be fair for you. And you haven't seen the document. I have no problem giving you time to review it and analyze it. So if you review that, and if you think you need counsel or something, when we recall the case, if you'll ask me for continuance, I'll consider it, okay?
Good.
All right. So if you'll have a seat, we'll recall your case later. Does that take care of all of the people at the for the consent affidavits?
Ms. Graves, did you have any other respondents present on affidavits of noncompliance? I believe that takes care of everyone present.
All right. As I say, I'm going to have to call his case out of orders to make sure that if he's got a copy of the affidavit, if somebody will take care of that, and then give him an opportunity to review it. With respect to the remainder of the consent affidavits, I'll accept those as stated. Brings us to old business. Other than me, it appears to be none. So it takes us to agenda item 10, new business. I understand we have council present on agenda case Y, COD 16-1876, Philip and Sharon Popa, co-trustees. If you're hearing that case, please approach.
I'll just put this one down here, get it out of the way.
Okay, thank you. Good morning, Mr. Sturgis.
Good morning, Magistrate. How are you today?
Doing fine. Would you announce your appearance for the record, please?
I will. Ernest Sturgis on behalf of the respondents Philip and Sharon Popa. Mr. Popa is present with me.
Okay. Good morning, sir. Good morning. I know Mr. Sturgis is familiar with the process, but we will have the county go first, and then you will allow you opportunity to present any evidence that you wish in opposition. So if the county is ready to proceed, you'd call your first witness.
Officer Rotahorse.
Good morning. My name is Gary Rotahorst, a certified code compliance officer for Charlotte County. The location of the violation is 23414 Painter Avenue, zone RSF 3.5. The owner of record is the Popa Family Trust. On June 27, 2016, I conducted an inspection of the property, finding a prohibited tractor on the property. I conducted an inspection on August 3, 2016, and found the tractor on the property again. I took photographs of the property on June 27th, August 3rd, September 27th, October 21st, and December 2nd, 2016. These photos fairly and accurately reflect the conditions I observed. I'd like to offer the photographs into evidence as County Composite Exhibit Number 1.
No objection.
Okay. Thank you. There being no objection, those will be admitted into evidence and marked. County Composite Exhibit 1, please proceed.
The notice of violation was sent in accordance with Florida Statute 162. The respondent was given 10 days to come into compliance reference the existing violation. The case is presented as a repeat violator due to the fact that on June 5th, 2013, a finding was found by the Charlotte County Enforcement Board for prohibited use in structures for a prohibited tractor parked in the driveway on a trailer. A 2-year cease and desist was ordered, which would have expired shortly before this violation. On December 2nd, 2016, I conducted a final inspection. I did not find a tractor on the property at that point. And that concludes my testimony.
Thank you, sir. Anything further from the county?
Just the recommendation.
Mr. Sturgis?
Magistrate, we're not contesting the allegations. Mr. Popa has removed the tractor, as you can see from the photographs. The tractor has not been at the property since he received the notice of violation. From what I understand, the recommendation will be we're in agreement with that. And so at this point, we're prepared to move forward to resolving the matter.
All right, and the county's recommendation?
The county recommends respondents be found in violation of the code sections listed in the notice of violation, and from the date of this order, a 5-year cease and desist order for any future zoning violations, and 15 days to clear the zoning violations, or thereafter face a fine of $100 per day for each day a violation exists.
All right, and Mr. Sturgis, you've heard and understand the recommendation?
I have, Your Honor. The only caveat I have is that Mr. Popa occasionally uses the tractor to do work on his property, to move dirt and things like that. I understand from speaking with Ms. Patel that if the tractor was there solely for that purpose and was not to remain on the property overnight, was just there to do the work and then be returned to his business, that would not be considered a violation of the cease and desist order or the county code. And I just want that stated in the record and as part of the order so that there is no misunderstandings in the future.
All right. Well, we appreciate that it's been addressed, but as long, you do understand, as long as that there's no further violation, there won't be a fine with this.
That there's no fine being entered today, yes, we understand that.
Okay, that's fine. All right, Charlotte County versus Philip G. Popa and Sharon Popa co-trustees, the Popa Family Trust, dates June 17, 2008. Charlotte County case COD 16-1876, pertaining to the parcel of property at 23414 Painter Avenue, Port Charlotte, Florida. I find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation. I'll accept the county's recommendation as my order, and we will have a copy over to you of the order.
Great.
Thank you. Have a good day, gentlemen.
Thank you, Magistrate. Take care.
There we go. All right, we're going to move to agenda item C, I'm sorry, G, if I have that correct. Okay. COD 16-2891, D. Steinbaugh trustee. If you're here on that case, if you'd please approach the podium and provide us your name, please. Morning, sir.
My name's William Borey. I'm the tenant.
The tenant, yes, sir. Okay. Sir, we'll be happy to listen to anything you have to say. County goes first. Just be patient, okay? Thank you, sir. County's ready to proceed. It's first witness.
Officer Leonard.
Name's Rhonda Leonard, Certified Code Enforcement Officer for Charlotte County. 3468 Westland Terrace is zoned RSF 3.5. The owner of record is D. Steinbaugh as trustee under trust number 6, dated October 31st, 2008. On September 14th, I conducted an inspection finding the following violation of outside storage of miscellaneous items, including but not limited to cinder blocks, an engine hoist, trash, tires, pallets, and assorted other debris, creating a junk-like condition and a prohibited use of the property. During the investigation, I took photographs of the property on September 14th and December 1st. These photos fairly and accurately represent the conditions I observed. I'd like to offer the photographs into evidence as County Composite Exhibit 1.
Sir, do you have any objections to me admitting these into evidence?
No, I don't.
Okay. There being no objection, I'll admit these as and mark them as County Composite Exhibit 1. They'll be admitted into evidence. Please proceed, Ms. Leonard.
The notice of violation was served in accordance with Florida Statute 162 and was prepared as a recurring offender due to 6 previous cases for the same violations, the last one having been dismissed in April of 2016. Respondents were given 10 days to come into compliance with the listed violations. I conducted the final inspection on December 1st, finding the property has been cleaned up with exception for a couple of boards and boxes. I've brought this case to hearing to obtain a cease and desist order due to all of the previous cases. This concludes my testimony.
Thank you. Anything further from the county?
Nothing further.
Sir, what have you got to say?
Well, I was gone for quite a few times throughout that because I'm a nurse and I travel all over the place and I work overnight. So it did get out of hand and I did get it cleaned up when I found out.
All right. Anything further, sir? Yeah. County recommendation, please.
The county recommends respondents be found in violation of the code sections listed in the notice of violation, and from the date of this order, a 2-year cease and desist order for any future zoning violations, and 15 days to clear the zoning violations, or thereafter face a fine of $100 per day for each day a violation exists, abatement in the event of noncompliance, and costs of abatement to be added to the fines and costs.
Okay. Charlotte County versus D. Steinbaugh, COD 16-2891. pertaining to parcel at 3468 Westland Terrace, Port Charlotte, Florida. I find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation, and I will accept the county recommendation. And I know you're not the owner of the property, but it sounds like you just have a couple of boxes or something to clean up, and there's no fine for anybody if you can get that done.
No problem.
Okay, great. Then we'll make sure, since you're the tenant, make sure everybody's got your contact information. We'll get you a copy of the order. Okay? Have a good day, sir. Yeah, I think it takes us to N.
Do what?
Takes us to case N.
Yes.
Okay.
She's got those
Okay,
cases.
thank you. That'll move us to agenda case N as in Nancy, Robert and Katrina Wernowick, Nick, I'm sorry, trustees. If you're here on that case, if you please approach. Bear with me just a second. The county is ready to proceed its first witness.
Officer LaRue.
My name is Chris LaRue, certified code enforcement officer for Charlotte County. 1854 Little Gasparillo Island is Zone BBI, Bridgeless Barrier Island. The owner of record is Robert M. and Katrina Warnick. Trustee of the Warnick Living Trust, dated May 28, 2013. This case was initiated on October 28, 2016, after code enforcement received an affidavit from Jack Boyer, the owner, were in violation of the Charlotte County Code 3-8-42, subsection D, connection to available private potable water distribution system. I have not had any personal contact with the owner. Notice of violation was served in accordance with Florida 162. As of December 7, 2016, this address was still not in compliance. This concludes my testimony. I would like to offer Jack Boyer for any additional testimony.
Please call.
My name is Jack Boyer, Vice President of Little Gasparillo Water Utility, being duly sworn in, and states the following. I own and operate a potable water system that is properly permitted by all applicable federal, state, and local agencies. The potable water system is in regulation, compliance, and provides potable water for human consumption through pipes and other conveyances. The potable water system has at least 15 service connections or regularly services at least 25 individuals daily, at least 60 days out of the year. The potable water system is investor-owned potable water utility company. Regularly, the structure is located at 8154 Grand. Little Gasparillo is capable of being connected, and plumbing has adequate permitting capabilities to supply potable water to the structure. A water line exists in the existing right-of-way and the property line of the structure. In March of 2016, I notified the property owner that central water service is available. As of today, the property owner of the structure has failed to obtain an exemption from the connection required and has failed to connect to Little Gasparillo Water Utilities potable water system.
Thank you, sir. Anything further from the county?
We would like to offer the affidavit of Jack Boyer and an order from the Public Service Commission granting a water certificate to Little Gasparilla Water Utility, Inc. Into evidence as County Composite Exhibit 1.
You would present it to the owner and...
Oh, that's okay. I've actually seen it. But I have testimony. Okay.
Okay. What we'll do then is, let me just take a look at it, and let me mark it first. I'll mark that as Composite Exhibit 1 for the county. Give me a second to take a quick look. There is a blank in the affidavit for the date, but I noticed that he testified to it.
Yes, Your Honor.
What's the age of this house, this property, the improvement on it?
Excuse me?
How old is the house? Inspector, do we know?
Built in 2008.
2008? Okay, thank you, sir. Yes, sir.
Good morning.
Morning, sir. And you are?
Robert Warnick, the owner of the home and the trustee.
I apologize if I mispronounced your name.
No worries. I may have over-prepared a little bit for this, so bear with me.
fine.
You can give me the sign if you've heard enough.
That's all right. I want to make sure you have an full opportunity to present whatever you deem appropriate. So,
I'm the owner of 8154 Little Gasparilla Island. I bought the house in December of 2012. At that time, there was no potable water system when I purchased the home, but the house did have a 2,500-gallon rainwater collection water cistern distribution system within the home. The house is used by family members only. The house is not offered for rent. The house is occupied about 4 times per year for about a week, each stay during family vacations. In the spring of 2013, I invested approximately $4,000 to install an additional 2,500-gallon water collection cistern, a 6-step filter progressive water filtration system, and a UV treatment unit for establishing potable water. My potable water is tested annually. Every test is returned that the potable water of the system yields water as pure as bottled water. Prior to the letter from LGI Water, dated and received after the deadline to file for a water system exemption, I had not received any information at all from Charlotte County or LGI Water.
when did you submit that?
The letter was received on March 3rd. The exemption filing requirements for the county was January 1st? February 1st. So I received a letter stating I hadn't received an exemption after the expiration and the deadline of the exemption period. By the nature of this lack of communication, by design or omission, the deadline was missed. Changing my system from a proven established water system that yields safe drinking water for my family would require me to find compelling information that the proposed water system was permitted, installed, and maintained in such a manner that abandoning my current water system is the right choice for my family. So I began a due diligence process after receiving the letter. I discovered that LGI water distribution system had not been physically inspected by the permitting authority, the DEP. Further, I contacted the Florida Public Service Commission and obtained public records and revealed that there were a number of violations committed by LGI Water, to include having connected over 100 homes to the system prior to a permit being issued and without the use of a licensed plumber, and a failure to issue water quality warnings to consumers after at least 2 water breaks. That's all public information, I believe. I think I have enough copies for you. There was a fine paid for these violations of approximately $6,000. Additionally, LGI Water has laid lines in violation of their permit by not securing appropriate easements with property owners for water line distribution and after this date and the results will face potential litigation. Requiring me to connect to the water system that has violations and places undue risk to my family's safe drinking water and our pursuit of life, liberty, property, feels like it's an overreach and an infringement. Over the next few minutes, if you'd like, I can lay out very specific time, dates, and documents to support the statements that I've made. I'll not bore you with the details. However, there are a number of issues at stake here, including that a number of water system improvements that were mandated by the Florida Public Service Commission and the DEP are in process and have not been completed by the water company. I learned last week that they have filed a second extension to be able to comply with those requirements, and the due date for those enhancements to the water system are actually December 15th, 2016. So I'll summarize. I won't go into the next page, but I hope that, shedding some light on this situation and the business practices will, have an effect on the compliance order. It's difficult for me, and I hope you can understand that complying with this mandate, needs to be in the best interest of my family and our safe drinking water. It feels as though, and having talked to a number of people on the island, that the cards have already been dealt. And anyone who did not immediately comply with the demands, the deck was loaded here. I mean, there's no way to comply when you receive a letter after the due date for the exemption. Jack asserts himself, well, I'm not going to get into that's not fair for this court to understand. But I think in summary, what I'd like to ask is that I invest over $4,000 for a water system that creates safe drinking water for my family that's tested annually. I'm being asked to attach to a water system that has come into play after I established the water system and not having an opportunity to file for the 5-year exemption from the water system. The connection fee to this water system is $4,923. So now I'm being asked to, spend upwards of $10,000 to establish safe drinking water for my family, which I already have.
So the first notice you received was in March?
March 3rd, I have that letter, 2016.
I'll take your word for it.
Okay.
Anything further, sir?
No. Thank you.
County.
The county calls Jack Boyer. Mr. Boyer, do you have any pending orders by the Public Service Commission or the Department of Environmental Protection against you that are adverse to your utility company?
No, ma'am. In the 30 years we've been operating, we've never had a compliance order. We've met all requirements. What he's referring to is one time a bacteriological notice had not been sent, and by law we have to notify. On the Public Service Commission, we're in the phase 2 of a construction process where we're building a building. And due with SBA funding and things of this nature, we've had to extend that. Application has been made to the Public Service Commission to extend that, but we're in total compliance with everything.
And has the respondent ever contacted you to try to obtain an exception from the connection requirements?
I apologize, I don't understand the question. Has who contacted?
Mr. Wernick, has he ever tried to contact you to find out any information about how to
Yes, ma'am.
become exempt?
Communicated one time. We played phone tags a couple times. I understand exactly where he is. This area that he is in the house that he was in, I provided water to many times on an emergency basis where they did not have water on his previous owner. As a matter of fact, I provided it to that whole area many a times, just trying to be a good neighbor with the utility while we were in the process of obtaining the easements and the proper permits to get down there.
And do you have any further information to add?
No, ma'am. I understand where he's at. I just want to be we just want to provide a service that we're obligated to do inside that certificated area.
Ms. Patel, would you answer a question for me on 3-8-42D as in David? Give you a chance to read that. when he gets a notice in March, and the deadline was 2 months earlier, how does he reconcile that?
Well, if the county had received an application after the fact, it would have processed it as well, if there had been any demonstration that the notice had been received after the deadline.
So it's not a fixed date that if somebody gets a late notice or something and submits the application, it would have been considered?
Correct.
Anything further, sir?
If I can respond to two
Please.
things. One is I have a letter here dated. So the letter was received on March 3rd. I did author a letter dated April 20th to Jack Boyer going through the fact that I had received his notice and that, I was surprised that I had not been notified by the county of any requirements to connect, and the fact that the letter was dated after the exemption. And, I'm a letter of the law guy. It says if you didn't file by this date, you are not going to receive an exemption. So I have this communication, as well as on August, I did not receive a response to that letter. On August 30th, I went out to the island with my family and discovered that a water line had been laid across our property outside of the utility easement. There is a 6-foot utility easement around each plat that's noticed in our documents for the declaration of the property. But this water line was not laid in accordance with the easement. I did send Jack an email, and he did respond back to me. I also filed a complaint with the Florida Public Service Commission. They notified me that easement violations are not in the jurisdiction of the Public Service Commission and that my remedy was through the Charlotte County Court for an easement violation. Jack did call me back on that, and he said that because it was a easement of necessity, that he didn't need to have an easement, which requires me to hire an attorney, and I get all that, and that's kind of part and parcel to this. But in summary, what I'd like to say is that there was no information ever shared that I can miss the deadline for the exemption, so that's new information to me.
Sure. And you'd spent your $4,000 when?
Spring of 2013.
Okay, so that was long before the...
There was no potable water system available to me at that time when I installed that system. That's correct.
Okay, thank you, sir. Anything further?
No, sir.
Your Honor, the county is willing to continue this case and review the matter further to determine whether an exemption would be possible for the respondent.
Listen, I approve of that wholeheartedly. So what we're going to do then is we'll continue this, and then, the county will be in touch with you, and hopefully we'll get this thing worked out, okay?
Thank you, sir. I appreciate it.
Okay. Next case we'll go to is...
I have a house on Little Gaspar also. I'm going through the same process, but my date isn't until February 2nd. I just came today to hopefully nip it in the bud and get it done.
what is your name, sir?
My name is Greg Adams.
Come approach the podium. Since he's here, I guess I'll just call his case next.
I appreciate it. Thank you.
Your Honor, I believe he's not on the agenda today.
Oh, he's not? Okay.
No, sir. Not until February.
Oh, okay, I see. I understand.
My idea was I called in, and when I got the letter, I talked to a Mr. Brown, and he informed me today that there would be cases that I could hear and have a chance to speak on this. I never...
Here's the problem,
okay.
sir, and I'd love to accommodate you, but we have a fixed agenda that I'm required to follow, and you're not on it.
Right.
You're welcome to stay and listen to the other cases and everything, but I think what you might want to do is see how the other cases go, and then maybe get in touch with the county afterward if you think that's appropriate, okay?
Okay. Just in closing, my case is exactly like Mr. Warnick's. I have a water system that I had installed. My water tests out perfect. I was never given that letter that I had to comply with him until March. I got a letter.
I understand that.
And so it's the same exact thing. It's just that my
Mine is in
Oh,
February.
you learned something new already about the belated application, so.
Right.
All right, so what we'll do is I guess we'll hear your case in February 1st, if you don't get it resolved before then, okay? And I don't mean to be rude, and I apologize.
No, I
But
understand.
I have a strict schedule.
I guess I was given some misinformation by Mr. Brown with the code enforcement, I guess, that I would have a chance to speak on this.
Well, you may get it worked out before February 1st anyway, so we'll
Right.
go ahead. If it didn't, we'll hear your case at that time, okay? But
I understand.
we've got to address the other people.
Okay, thank you.
Thank you. Vote is continued? Okay. Okay, so for the record, case LGW 160002, Kinsey Clyde Tillman, that case has been continued, I've been informed. Is that correct?
Yes, Your Honor.
Okay. Let me see where that leaves me. I believe R is the next one. Agenda item R, COD 161007, Minavone and Sibareth. I can't pronounce the last name. I apologize. Your name, sir?
Kenneth Siharat.
Okay, good morning, sir.
Morning.
I apologize for butchering your name. We'll go with the county going first, and then we'll hear whatever evidence you have, okay?
Thank you.
So if you have any photographs or anything you want me to consider, just have that ready, okay? If you'll bear with me 1 second. I take it that Officer Moore is your first witness?
Yes, Your Honor. Officer Moore.
Whenever you're ready.
My name is Renelle Moore, Certified Code Enforcement Officer for Charlotte County. 3421 Amanda Street is zoned RSF 3.5. The owner of record is Minavone and Sarath. I don't know how to pronounce it as well. I apologize. This case was initiated by myself September 19, 2016, when I conducted an inspection of the address and observed the following violations: of outside storage of miscellaneous items, including but not limited to an inoperable vehicle in the driveway, wood, plastic, buckets, and other assorted debris, creating a junk-like condition and prohibited use of the property. There is also a big text-type trailer being stored on the property. A courtesy letter was sent to the owner's address outlining the violations and allowing 10 days for compliance. During the investigation, I took photographs of the property on September 19th and December 6th, 2016. These photos fairly and accurately represent the conditions I observed. I would like to offer the photographs into evidence as County Composite Exhibit 1.
She's going to show you some photographs, and if you would take your time and look at each of them and let me know if you have any objection to me entering those into evidence. Okay, there being no objection, we'll go ahead and mark those as Charlotte County Composite Exhibit 1. If you'd please proceed, Officer Moore.
The notice of violation was served in accordance with Florida Statute 162. I've had no contact with the owner. On December 6, 2016, I conducted the final inspection, finding that the violation still existed. This concludes my testimony.
Anything further from the county?
Nothing further.
Sir.
Yes, the truck
I'm ordered a part to fix it, put on the road.
The white truck?
Yes, sir.
Okay.
And a trailer, one of my friend trailer, he put in there. He's going to put in the landfill, but his truck broke down. So I would like to ask you sometime to get it done.
You need some additional time?
Yes, sir.
How much time do you think you need?
What maximum you can give me? Because I'm ordered part coming for the truck now.
Mm-hmm.
I'm going to put on the road pretty soon.
Anything further, sir?
No, sir.
Okay. County recommendation?
The county recommends respondents be found in violation of the code sections listed in the notice of violation, and from the date of this order, a 2-year cease and desist order for any future zoning violations, and 15 days to clear the zoning violations, or thereafter face a fine of $50 per day for each day a violation exists, abatement in the event of noncompliance, and costs of abatement to be added to the fines and costs.
Thank you. Charlotte County case COD 16-1007 pertaining to the property located at 3421 Amanda Street, Punta Gorda, Florida. I find that the undisputed evidence establishes the existence of the a violation. I will accept the county recommendation, except I will give you an extra 15 days, so it'll extend it to 30 days. So you get this taken care of within the 30 days. There won't be any fine, okay?
Yes, sir. Appreciate it. Thank you.
I'll change that. Okay, thank you. That's the old one. Sir, have you had a chance to see the affidavit, any paperwork since you were up here?
I don't see the violation of the pictures. They're not the pictures I can barely make out at all. I can't tell you what's going on with
Would you come on up here?
Sure.
Sure, no, I mean at the podium.
You can understand what I'm talking about.
Yeah, come if you'd bring them up here. Have you seen it? I guess these are ours, sir.
I'm sure the data files on these screens are nice and big.
I requested a data file from the lady who gave me these. She said she was only allowed to give me these.
Mm-hmm.
I can't tell you what's going on. I can't argue a violation if there isn't. And it's not I'm not trying to be compliant. I am. I'm getting tired of dragged in here. Of course I'm trying to be compliant. But what am I doing? What is going on that, I can correct to stop this? I'm not trying to be argumentative. I'm just...
That's not a problem. There's nothing wrong with asserting your rights. So
I really wish that not be televised.
Unfortunately, I don't have the authority to stop that.
No, I mean, you can stop the presentation.
Well, I can't, though. And so are you ready to proceed, or would you want a continuance?
I would request a continuance because I want to look at the data files and find out where the violation...
That's fine, and that's what I'm going to do because I think that's in all fairness to you, okay? So we'll go ahead and continue that consent affidavit.
Honestly, it looks like somebody came by when I was cleaning out a trailer.
I'm sorry?
Honestly, it looks like somebody came by when I was cleaning out a trailer.
Okay, well, we'll consider that, but you think you're going to need counsel or you need something further, there's methods for you to get that information. So I'm continuing your case. I'm going to continue your affidavit hearing until next meeting, February 1st.
Thank you, sir.
You're welcome.
I would like to request a data file of these. I've been calling the office several times. Nobody calls me back.
Yeah. All right.
I don't know.
If you make a records request, we will give you that information. We're allowed to do it in a reasonable time. Okay? No, you have to do it through the proper channels. This is the hearing officer. We'll do it over here.
Sir, if you want to, just write a letter and ask them for the documents, and that's fine. I've continued your case, so you're done for today. Okay?
Thank you, sir. What's the date of the next?
We're going to continue to February 1st.
Thank you.
Okay? Thank you, sir. Did you want these photographs back, sir?
Yes, I do. Thank you very much, sir.
You're welcome.
Yes, sir. I don't dispute you.
Don't worry about it.
Data files.
All right. Agenda item S, COD 161122, Richard and Hazel May. If you're here on that case, if you'd please approach. Your name, ma'am?
My name is Gladys Reynolds. I'm the daughter. I live in the house. My parents are deceased, both of them. So I'm basically, I guess you'd call the owner for the time being.
Okay. The title to the property, is that in your name?
No, sir, it's in my parents' name still. We never changed it.
Is there a probate or?
No, my sister and I are the only two living relatives at this point in time. There's been issues in his guards. They bought it in 1967. It was residential professional because my father was a commercial fisherman. He ran his business out of there, Peace River Seafood, for a while. He had, all his documentation for all of that. I don't have access to it but at that point in time, he was told he could have his boats, trailers, fishing equipment, everything required, for his business.
We'll get to that in a
Sure.
moment, but what I'm trying to figure out is the status of the title to the property, and you and your sister are the only two heirs, and when was the last of your parents died, the date?
My father passed away in 2006.
2006, and there's never been
No,
anything?
we've never. I've lived there pretty much my whole life. We just never followed through with it.
I understand.
Honestly, we didn't have the funds to follow through with it.
I know, but there was a legal reason I was asking
Oh,
for that.
I'm
Okay, but what we'll do is we'll give you a chance to explain.
Sure.
The county will go first, and then we'll go back and readdress some of the things that you mentioned, okay? If the county is going to call Officer Moore, if she'd proceed.
Officer Moore?
My name is Renelle Moore, Certified Code Enforcement Officer for Charlotte County. 1815 La Villa Road, Punta Gorda, is zoned OMI, Occupational Medical Industrial. The owner of record is Richard and Hazel May. The case was initiated by myself on August 16, 2016, when I conducted an inspection of the address and observed the following violations. Outside storage of miscellaneous items, including but not limited to tools, broken grills, metal, barrels, buckets, televisions, furniture, lawnmowers, and assorted other debris, creating junk-like conditions and prohibited use of the property. There is also 3 boats on the property as well in disrepair. There's unlicensed inoperable vehicles and cargo trailers. There was also a damaged roof at the time, holes in the exterior walls, unsafe electrical wires in the main fuse box, and no insect screens on the damaged windows. A courtesy letter was sent to the owner's address outlining the violations and allowing 30 days for compliance due to the electrical issues. During the investigation, I took photographs of the property on August 16, 2016 and December 6, 2016. These photos fairly and accurately represent the conditions I observed. I'd like to offer the photographs and evidence as County Composite Exhibit 1.
I know what they are. We've already. That's fine.
Ma'am, do you have any objection to me admitting those into evidence?
No, that's the way it looked when she took the pictures. It doesn't look like that now, but that's what it looked like then.
Thank you. Those will be marked as Charlotte County Composite Exhibit 1 and admitted into evidence.
The notice of violation was served in accordance with Florida Statute 162. I have had correspondence with the owner and by phone and in person over the investigation. There has been some noted progress, and I just wanted to note for the record that she's been very cooperative, and there has been some progress, but there are still violations existing. On December 6, 2016, I conducted the final inspection, finding that violations still exist. This concludes my testimony.
What do we have that's still left to do?
There's abandoned boats that are still there. She has sorted out I know she's been having difficulty getting rid of the boats. The roof has been patched up. That there was it just needed some tar put on it and a couple of shingles. The electrical fuse box, to my knowledge, she was still waiting for the electrician she hired to obtain the permit to repair that. So I suggested that she come and explain the situation today.
Okay. Thank you. Anything further from the county at this time?
Just the recommendation.
All right. Ma'am, you want to tell me what's going on here?
Okay, you were basically, the first pictures are an accumulation of my father, my two brothers. You know, this is their mess that they accumulated over the years. I'm glad to get rid of it. I'm trying my best, but I'm limited fund-wise as to being able to pay to have this done. I put a dumpster there. It held a ton, actually, of stuff that was taken from the property. Might not look like it, but there was a ton. So we're trying. I sorted the metal, anything that she suggested that we could possibly get some funds from it if we take it, and might help to offset some of these. The roof, the tarp is no longer there, and this house was built in '67. It has dog houses. I don't know if you understand what that is, but right around the edges of them, the rain gets underneath, the water travels. So we are eliminating the leaks, and I have a coating that's going on it once we get all the leaks. Actually, the last rain, there was no leaks, so we're hoping we've got that accomplished. C-Ray Electric, they wanted $1,200 in order to replace the panel that she's talking about. He would accept $800 down, and to get the permit, to get FPL in, because they have to come out and turn it off for him to be able to do it, and then I'd owe $400 more. Right now, Stephanie at Children and Families is working towards getting funding to help me with that expense, because basically I have been family caregiver forever. You know, first with my parents, my two brothers who passed away, both of them in 2013. There goes my help as far as to get rid of the stuff. Right now, I have a newborn baby there born March because my niece, drug issues, it was either I take her in or she lose her baby. So all of this is like compiling on me at one time. And I really am trying to comply, but it takes time and money, which I don't have right now, but I am trying.
I have no doubt. The officer acknowledged that you were making a good faith effort.
Now, Stephanie did not give me a time frame as to, I don't know where she's applying for this funding. Once I hear from her, I've contacted Ray's Electric. He understands because it's way beyond, the 30 days when I initially signed the contract with him. He's very cooperative. But he did tell me FPL, even though he calls them, sometimes they can't get out there right away, so it still might be a little bit of a delay even once I can get him, out there to do this. I just basically need time, is what I need.
It's okay. Well, let's see what the county wants to do.
Can I also point out, though, we live 100 yards off the road. You can't you can't see my property from the road. You don't even know there's a house back there. And again, it was built in 67. It's all wooded, all treed. I understand the need to clean it up. I really do, and I'd love to have it cleaned up. But, again.
All right. Well, let's see what the county wants to recommend. So may I have the recommendation, please?
I'd like to note the county is dismissing Section 105.1 of the Florida Building Code and Section 304.7 of the International Property Maintenance Code.
Okay, those will be granted.
And the county recommends respondents be found in violation of the code sections listed in the notice of violation as amended, and from the date of this order, a 2-year cease and desist order for any future zoning violations, 30 days to clear the zoning violations, and 30 days to obtain all necessary permits, then pass all inspections and bring the property into compliance with the International Property Maintenance Code, or thereafter face a fine of $50 per day for each day a violation exists, abatement in the event of noncompliance, and costs of abatement to be added to the fines and costs.
Thank you.
Can I add something else?
Certainly.
From what I'm reading, you're basically enforcing office, medical, institutional, industrial zoning. I don't understand that because it's been used as a residence for 50 years. How can you now come in and enforce? Because basically I'm told I can't even have a lawnmower in my yard. It has to be inside an enclosed area. I can't have ladders in the yard. It has to be in an enclosed area. I don't understand the necessity for that.
Well, I'll have you get together with these folks and they can explain to you why it is that that's applicable. But what we're going to do is, and this really is a difficult part of this job when I find somebody that's trying so hard and is having a difficult time, but they do have to enforce the law, so I'm going to try to split the baby here if I can.
I would appreciate any help you can give me.
All right. So, Charlotte County versus Richard D. and Hazel L. May, 16/11/22, pertaining to parcel located at 1815 La Villa Road, Punta Gorda, Florida. I find that the undisputed evidence establishes the existence of the violations set forth in the notice of violation. I'm going to accept the county recommendations and orders. That gives you an additional 30 days. I would urge you, though, I mean, if you're making a really good effort, please contact somebody if you're really having a problem and get together with them and they can explain to you on the zoning, okay?
Thank you.
That's a new printed one?
Yeah.
Okay, so let me go ahead and take care of that. Good luck with that. I hope you get it.
Thank you.
Okay, I think that takes us to case T as in Tango, COD 162118, William Cruz. If you're here, please approach the podium. Are you Mr. Cruz?
I'm William Cruz.
Good morning, sir.
Good morning, sir.
We'll pretty much follow the same procedure, so just bear with us, okay? I understand that you'll be calling Officer Moore, so if you're ready, Officer Moore.
Cornell Moore, Certified Code Enforcement Officer for Charlotte County. 119 Wilmers Road is zoned RSF 3.5. The owner of record is William M. Cruz. The case was initiated by myself August 25, 2016, when I conducted an inspection of the address and observed the following violations. A houseboat and a cargo trailer on an undeveloped lot, and by admission, living in the house, Mr. Cruz was living in the houseboat on the property, creating a prohibited use of the property. A courtesy letter was sent to the owner's address outlining the violations, allowing 10 days for compliance. During the investigation, I took photographs of the property on August 25th and December 6, 2016. These photos fairly and accurately represent the conditions I observed. I would like to offer the photographs into evidence as County Composite Exhibit 1.
Mr. Cruz, you have any objection to me admitting those into evidence?
No, sir, I do not.
All right, those will be marked County Composite Exhibit 1 and admitted into evidence. Please proceed.
The notice of violation was served in accordance with Florida Statute 162. I have had contact with the owner and discussed the situation, and at this point, during my final inspection on December 6, 2016, I conducted my final inspection, and Mr. Cruz has removed the houseboat and no longer lives on the property, but the cargo pod still remains. And this concludes my testimony.
So if I understand your testimony correctly, then initially he admitted he was living in the,
Yes, Your Honor.
and now he's since moved out.
He's removed the boat and is, I believe, living, last I knew, living on the water in his houseboat.
All right, but the what I'm seeing here still is the conditions.
Yes.
Okay, thank you. Anything further from the county at this time?
Nothing further.
Mr. Cruz, what's going on?
Your Honor, I've been living on boats for a while, and I decided I wanted a house. So I saved some money up. I bought me a lot, a nice area, friends, everything. And I cleared the lot, got my permit, and cleaned it up and everything. And I put a culvert in it, and I've got my house prints done. I've got my site plans done. I've spent several $1,000s, which I live on a little over $1,000 a month. And I really wanted this house, and I guess my neighbors, I didn't get my electric in, so I have to run a generator from time to time. It's a boat I actually made on a 24-foot pontoon, has solars and run by batteries. But it just, I didn't know I couldn't live there while I built the house. I figured I'd be in there a couple of years, I'd be able to build the house. You know, it's the only way I could do it. I don't drive, I'm disabled. I just wanted to, do this in my last shot. They told me that I couldn't do it. Like I said, I'm low on funds. The last thing I did was my site plan, which was $850. It took me 3 months to pay that off. And at the same time, all this came up. I did get a letter. They keep calling this a cargo trailer, but one of the papers that they gave me, it said any cargo containment area larger than 20 foot is illegal. Now, it's only a 20-foot trailer, so that's cargo containment area the way I look at it, and that's why it's still there. I can't afford to put all that stuff in storage, and I can't afford to move it anywhere and pay storage for it. If it's illegal, I would like to ask courts mercy and give me a few months in removing it and figuring out, what I can do with it and get rid of it. But I was trying to build a house.
Sure, I understand. Anything further?
Not right now, sir.
County's recommendation, please.
I'd like to note that county is dismissing Section 3-9-79.1 of the Charlotte County Code. And the county recommends respondents be found in violation of the code section listed in the notice of violation as amended, and from the date of this order, 30 days to clear the zoning violation, or thereafter face a fine of $50 per day for each day a violation exists.
All right. Okay, Section 3-9-79.1 will be dismissed. Charlotte County versus William M. Cruz, case COD 16-2118, pertaining to parcel located at 119 Wilmers Road, Punta Gorda, Florida. I find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation. I will accept the county recommendation as my order, so that will give you an additional 30 days. I don't mean to make your situation any more difficult, but I kind of have to.
So that is a cargo trailer then, instead of a containment area, is what you're telling me?
Yes, sir. And then,
what is a containment area?
Well, sir, I can't get into.
Okay.
Just to clarify quickly here, that's not a trailer. There's no wheels on it.
What didn't?
There's no wheels and tires at that point. We can't call it. Yeah, no axles. We can't call it a trailer of any sort. It's a storage pod at this point.
Okay, I couldn't tell from the photograph. Okay. It's a storage pod.
Thanks, sir.
Okay, thank you, sir.
And it's only 20 feet in length, which is the cap for the size of them.
Okay. So that's my order, sir. You'll, if you run into a problem, I'd suggest that you call the county and see if you can get some additional time, but I've gone about as far out as I can to help you out.
All righty.
Look like it doesn't have, that's flat on the bottom? Okay. But the wheels have been taken off of it. Okay, so I think that takes care of everybody that was here, right?
Yes, I think that would take us to the DOH cases.
I'm sorry?
I believe that does take care of everyone present and would take us to the Department of Health cases.
Okay. So is your preference to take a break now, or you just want to keep moving, or?
We could move along through the DOH cases.
Okay, so let me see, which is our first agenda for
I
the,
believe that's tab J.
I'm sorry?
Tab J.
Oh, okay.
Dismiss. Tab K.
One second. Okay, J's dismissed. K, okay, so DOH 15562, Keith Moreland. I note that no one is present on behalf of the respondent. So if I understand, Officer Brown will be testifying?
Officer LaRue.
Oh, LaRue, oh, okay.
Yeah, I need to find that.
Wrong name on her.
That's 15-00562.
Changed up on me.
Well, he's had a family.
Oh, I see. All right, whoever your first witness is going to be.
Sorry.
If we could have a moment.
Yeah, that's all right.
Are there any more?
No, that's the last one.
Actually, we are continuing that case. I apologize.
Okay. Did it change up on me on that one?
And me. Change up on me, too.
I was going to say you didn't look like Officer Brown. All right, so that will take us, is L dismissed?
I don't believe so. It is?
Doesn't matter. I can't.
And M is dismissed.
So we're good.
So I think that's the last of them, isn't it?
It appears to be the case.
I'm sorry?
Yes, Your Honor.
Okay. Alrighty. So we... Man. While you guys are discussing that, why don't we just go ahead and take a 15-minute, make a 10-minute break.
Yes, Your Honor.
gentleman is present on behalf of the owner, so if the county is ready to call its first witness, I will get the file. And
Officer Davis.
James Davis, Certified Code Enforcement Officer for Charlotte County. The property in violation is 102 Fitzsimmons Street and is zoned RSF 3.5. The owner of record is Bernadine J. Murray. On July 13th, Officer Anthony Jones conducted an inspection of the address and reviewed the Charlotte County permitting database, observed permit 2005-101-003 for a drywall replacement and a permit 2005-082-448 for new lighting, heater, and miscellaneous had expired without receiving final inspections. A courtesy letter was sent outlining the violations and allowing 30 days for compliance. I did a follow-up inspection on September 27th, 2016, and the permits remained expired. During the investigations, I took photographs of the property on September 27th. These photos fairly and accurately represent the conditions I observed. I would like to offer the photographs and permit history into evidence as County Composite Exhibit Number 1.
okay, those will be marked Composite Exhibit 1 for the county and admitted into evidence. Please proceed.
The notice of violation was served in accordance with Florida Statute 162. The respondent was given 10 days to come into compliance, referencing the existing violations. On December 6th, I conducted the final inspection, finding conditions remained the same. This concludes my testimony.
All right, have you had any communication at all with the owner?
No, sir.
Anything further from the county? If not, its recommendation.
The county recommends respondents be found in violation of the code sections listed in the notice of violation, and from the date of this order, 30 days to renew the expired permits and pass all inspections in accordance with the Florida Building Code, or thereafter face a fine of $50 per day for each day a violation exists.
Thank you. Charlotte County, Bernadine J. Murray, case COD 16-2154, pertaining to parcel located at 102 Fitzsimmons Street, Port Charlotte, Florida. I find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation and have accepted the county's recommendation as my order. Takes us to agenda item B, Michael Bertha Finnegan. I note that no one is present on behalf of the respondent. The county is ready to proceed as first witness.
Officer Davis.
James Davis, Certified Code Enforcement Officer for Charlotte County. Property in violation is 24325 Harborview Road, Lot 810. The owner of record is Michael and Bertha Finnegan, and the property is zoned mobile home park. On August 3rd, Officer Anthony Jones conducted an inspection of the address and reviewed the Charlotte County permitting database, observed permit 2004-118227 for replacement of the windows had expired without receiving final inspections. A courtesy letter was sent outlining the violations and allowing 30 days for compliance. I did a follow-up inspection on September 6, 2016, and the permit remained expired. During the investigation, I took photographs of the property on September 6th. These photos fairly and accurately represent the conditions I observed. I'd like to offer the photographs and permit history into evidence as County Composite Exhibit Number 1.
So marked and admitted.
The notice of violation was served in accordance with Florida Statute 162. The respondent was given 10 days to come into compliance, referencing the existing violations. On December 6th, I conducted a final inspection, finding conditions remain the same. This concludes my testimony.
Officer Davis, are these still showing up as delinquent in the records? It looks like your last visit to the property and examination of the records was September 6th.
Yes.
Okay, have you examined it since that time?
It was December 6th.
Oh, okay. I'm looking at, okay. It says September on your...
Oh.
Okay.
Are you looking at the cron?
Yeah. Don't worry about it.
I leave that blank to the last day that I fill it out.
Okay, I was going to say September goes back a long ways. Where'd it go? All right. County recommendation?
The county recommends respondents be found in violation of the code sections listed in the notice of violation, and from the date of this order, 30 days to renew the expired permits and pass all inspections in accordance with the Florida Building Code, or thereafter face a fine of $100 per day for each day a violation exists.
Okay. Charlotte County versus Michael and Bertha Finnegan, COD 162367, pertaining to property located at 24325 Harborview Road, Port Charlotte, Florida. Find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation, and accept the county's recommendation. What threw me was on the notes, it said September. I guess it was a typographical error.
It does. I check the cases the day before the hearing.
Oh, all right, well, that will take us to agenda item C, COD 162532, Philip J. Smith. I note that no one is present on behalf of the respondent. Officer Davis, whenever you're ready.
I believe we are continuing that case.
I'm sorry? Oh, for no service?
Yes, Your Honor.
Okay, no problem. We'll go ahead and continue that for lack of service. Forgot to mark it off on my agenda. Take us to agenda item D, BNK Real Estate LLC. I note that no one is present on behalf of the respondent. Looks like Officer Davis is at bat again.
James Davis, Certified Code Enforcement Officer for Charlotte County. The property in violation is 2390 Duncan Road and is zoned Commercial General. The owner of record is B&K Real Estate, LLC. On August 26th, I conducted an inspection of the address and reviewed the Charlotte County permitting database, observed permit 2007-090374 for replacement of 2 doors that expired without receiving final inspections. A courtesy letter was sent outlining the violations and allowing 30 days for compliance. I did a follow-up inspection on October 7th, 2016, and the permit remained expired. During the investigation, I took photographs of the property on October 7th. These photos fairly and accurately represent the conditions I observed. I would like to offer the photographs and permit history into evidence as County Composite Exhibit Number 1.
Those are so marked and admitted.
The notice of violation was served in accordance with Florida Statute 162. The respondent was given 10 days to come into compliance, referencing the existing violations. On December 6, 2016, I conducted the final inspection, finding conditions remain the same. This concludes my testimony.
Thank you. If the county has nothing further, its recommendation, please.
The county recommends respondents be found in violation of the code sections listed in the notice of violation, and from the date of this order, 30 days to renew the expired permits and pass all inspections in accordance with the Florida Building Code, or thereafter face a fine of $100 per day for each day a violation exists.
Thank you. Charlotte County versus B&K Real Estate LLC. COD 162645 pertaining to the parcel at 2390 Duncan Road, Punta Gorda, Florida. I find that the undisputed evidence establishes the charges set forth in the notice of violation and have accepted the county recommendation as my order.
Changing that one. She's been on your copy.
I'm sorry?
Had the amount on there wrong, so she's changing it.
Oh, okay. Well, I'll just stand by for a minute.
You're going way down one of the screens.
Okay, now we got it. All right, agenda case E, COD 122178, Svetlana Zimbabski. I think I've got that right. I note no one is present on behalf of the respondent, so if, looks like Officer Bush, you ready?
Yes. My name is Charlie Bush. I'm a certified code enforcement officer for Charlotte County. 21296 Davidson Avenue is zoned RSF 3.5, and the owner of record is exactly what you pronounced. On November 29, 2016, based on the review of the Charlotte County database, the address observed the following violation: an expired single-family residence addition permit, which expired November 27, 2016. During the investigation, photographs were taken on the property on February 13, 2015. These photos fairly and accurately represent the conditions I observed. I'd also like to offer the photographs with a copy of the expired building permit into evidence as County Exhibit Number 1.
Those will be so marked and admitted.
Notice of violation was mailed in accordance of Florida Statute 162. The respondent was given 10 days to come into compliance, referencing the existing violation. On December 5th, 2016, I conducted the final inspection, finding the permit remains expired. That is the end of my testimony.
If the county doesn't have anything further, its recommendation, please.
The county recommends respondents be found in violation of the code sections listed in the notice of violation, and from the date of this order, 30 days to renew the expired permits and pass all inspections in accordance with the Florida Building Code, or thereafter face a fine of $50 per day for each day a violation exists.
All right. In Charlotte County versus Zimbowski, case COD 12-2178, pertaining to a parcel located at 21296 Davison Avenue, Port Charlotte, Florida. I find that the undisputed evidence establishes the charges set forth in the notice of violation and accept the county recommendation as my order. All right, takes us to case F-16-2248, William and Patricia Henson. I note that no one is present on behalf of the owner. I see Officer Leonard is teed up, so you proceed.
My name is Rhonda Leonard. I'm a certified code enforcement officer for Charlotte County. 22101 Midway Boulevard is zoned RSF 3.5. The owners of record are William and Patricia Henson. On July 26th, I conducted an inspection finding the following violations of outside storage of miscellaneous item, including, but not limited to, sheetrock, wood, metal, plastic containers, tarps, boxes, and assorted other debris, creating a junk-like condition and prohibited use of the property. During the investigation, I took photographs of the property on July 26th, September 13th, November 30th, and December 1st. These photos fairly and accurately represent the conditions I observed. I'd like to offer the photographs into evidence as County Composite Exhibit 1.
So marked and admitted.
I spoke to Kathy Taylor, a resident, on August 11th. She stated the owner was out of town and requested more time. 30-day extension was granted. The notice of violation was served in accordance with Florida Statute 162. The respondents were given 10 days to come into compliance with the listed violations. I conducted re-inspections on November 30th and December 1st, finding no change in conditions. This concludes my testimony.
Thank you. If there's nothing further from the county's recommendation, please. F.
The county recommends respondents be found in violation of the code sections listed in the notice of violation, and from the date of this order, a 2-year cease and desist order for any future zoning violations, and 15 days to clear the zoning violations, or thereafter face a fine of $50 per day for each day a violation exists, abatement in the event of noncompliance, and cost of abatement to be added to the fines and costs.
Thank you. In Charlotte County versus William and Patricia Henson, COD 16-2248, pertaining to parcel at 22101 Midway Boulevard, Port Charlotte. I find that the evidence establishes the existence of the charges set forth in the notice of violation, and I have accepted the county recommendation as my order. Takes us to agenda item H, COD 16-3034, Jason and Heather Fisher. I note no one is present on behalf of the owner, so if the county is ready to proceed, please do so.
Officer Leonard.
My name is Rhonda Leonard. I'm a certified code enforcement officer for Charlotte County. 22016 Beverly Avenue is zoned RSF 3.5. The owners of record are Jason and Heather Fisher. On September 27th, I conducted an inspection finding the following violations of excessive growth of grass and weeds, outside storage of miscellaneous items including but not limited to tree debris, wood, furniture, tarp, buckets, plastic containers, bicycle parts, and assorted other debris, creating a junk-like condition and a prohibited use of the property. Damaged exterior walls, unprotected fascia and soffit, carport in disrepair, the residence being occupied without water service, and a fence-type structure constructed without a permit. The property was posted as unsafe and unfit for human habitation. During the investigation, I took photographs of the property on September 27th, November 21st, and December 5th. These photos fairly and accurately represent the conditions I observed. I would like to offer the photographs into evidence as County Composite Exhibit 1.
Those have been so marked and admitted.
The notice of violation was served in accordance with Florida Statute 162 by posting on November 21st. Was prepared as a repeat violator due to a previous case for the same violations of grass and junk. The cease and desist order expired in June of 2015. The respondents were given 10 days to come into compliance with the listed violations. Conducted the final inspection on December 5th, finding no change in conditions, and the water service remains off. This concludes my testimony.
Thank you. If the county has nothing further, its recommendation, please.
The county recommends respondent be found in violation of the code sections listed in the notice of violation, and from the date of this order, a 5-year cease and desist order for any future zoning violations, 15 days to cease using the residence for living purposes until utilities are reinstated, to clear the zoning violations, and either obtain a fence permit or pass all inspections or remove the fence structure, and 30 days to obtain all other necessary permits, then pass all inspections and bring the property into compliance with International Property Maintenance Code, or thereafter face a fine of $100 per day for each day a violation exists, abatement in the event of noncompliance, and cost of abatement to be added to the fines and costs.
Thank you. Charlotte County versus Jason and Heather Fisher, COD 163034, pertaining to parcel 22016 Beverly Avenue, Port Charlotte, Florida. I find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation and have accepted the county recommendation as my order. Takes us to Agenda I, COD 152665, Anthony and April Lanzetta. I note that no one is present on behalf of the respondent. So, it looks like we have Officer LaRue. If you're ready to go.
Chris LaRue, Certified Code Enforcement Officer for Charlotte County. The address is 4679 Fallen Circle. Property is zoned residential single family 3.5, and the owner of record is Anthony M. and April Lanzetta. This case was originally initiated by Officer Reinwald on October 20th, 2015. It was turned over to Officer Stephen Brown on June 15th. Due to circumstances out of our control, I conducted an inspection of the property on December 6th, 2016, and also noted in Charlotte County permit database that permit number 2005-01-3335 for roof redo was still expired. During the investigation, I took photographs on December 6, 2016. These photographs fairly and accurately represent the conditions I observed. I would like to offer these photographs in as evidence, County Composite Exhibit number 1.
Those would be so marked and admitted. Go ahead.
Notice of violation was served in accordance with Florida Statute 162. I have not had personal contact with the owner of the property. As of this morning, December 7th, the permit for roof redo is still expired. This concludes my testimony.
Thank you, sir. County's recommendation, please.
The county recommends respondents be found in violation of the code sections listed in the notice of violation, and from the date of this order, 30 days to renew the expired permit and pass all inspections in accordance with the Florida Building Code, or thereafter face a fine of $50 per day for each day a violation exists.
Thank you. Charlotte County versus Anthony M. and April Lanzetta, COD 152665, pertaining to parcel 4679 Fallon Circle, Port Charlotte, Florida. Find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation and have adopted the county recommendation as my order. I think that takes us to case Q, COD 16677, Martha Curran. I note that no one is present on behalf of the respondent. The county is ready to proceed. Looks like we have Officer Moore.
Renell Moore, Certified Code Enforcement Officer for Charlotte County. 15373 Orchid Drive is zoned MHC, Mobile Home Conventional. The owner of record is Martha Curran. This case was initiated by myself September 19, 2016, when I conducted an inspection of the address and observed the following violations. Outside storage, including 2 temporary canopy frames in disrepair, inoperable vehicles, a bed-mounted camper in disrepair, recreational vehicles in disrepair, and other miscellaneous debris creating junk-like conditions. Also, a utility trailer not being stored behind the leading edge of the property, causing prohibited use of the property. A courtesy letter was sent to the owner's address outlining the violations, allowing 10 days for compliance. During the investigation, I took photographs of the property on September 19th and December 6, 2016. These photos fairly and accurately represent the conditions I observed. I'd like to offer the photographs into evidence as County Composite Exhibit 1.
Those will be so marked and admitted. Please proceed.
The notice of violation was served in accordance with Florida Statute 162. I have had contact with the owner and explained to them that the violation still existed and must be taken care of to avoid further code action. On December 6, 2016, I conducted the final inspection, finding that the violation still existed. This concludes my testimony.
Thank you. County doesn't have anything further. Its recommendation, please.
The county recommends respondent be found in violation of the code sections listed in the notice of violation, and from the date of this order, a 2-year cease and desist order for any future zoning violations, and 15 days to clear the zoning violations, or thereafter face a fine of $100 per day for each day a violation exists, abatement in the event of non-compliance, and costs of abatement to be added to the fines and costs.
Thank you. Charlotte County versus Martha Curran, COD 16677, pertaining to the mobile home located at 15373 Orchid Drive, Punta Gorda, Florida. I find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation, and have adopted the county recommendation as my order. I believe that takes us to case or agenda item U, COD 16303 Mike Hester. I note that no one is present on behalf of the owner, and looks like we have Officer LaRue.
Chris LaRue, Certified Code Enforcement Officer for Charlotte County. 22457 Olean Boulevard is zoned residential single family. The owner of record is Michael Lee Hester. On February 1st, 2016, I conducted an inspection of the property, finding junk-like conditions consisting of, but not limited to, a pile of gravel, hand tools, wheelbarrow, scrap lumber, a plastic tank, and other items causing a junk-like condition and a prohibited use of the property. I also conducted a review of the Charlotte County permit database, finding permit number 2012-04-04342 was expired for a picket fence. Warning letter was mailed on February the 11th, 2016, and on March 11th, 2016, I had a phone conversation with the owner to discuss the violations. This case was originally set for hearing in June of 2016, but the owner renewed the permits on May 31st, and it was continued for the length of the permit till December hearing. On December 5th, I conducted an inspection of the Charlotte County permit database and found the permit had once again expired without being properly closed out. Site inspection was conducted, finding junk-like conditions consisting of, but not limited to, a plastic tank, hand tools, ladders, a car battery, a water cooler, and other items creating a junk-like condition and prohibited use of the property. During the investigation, I took photographs on February 1st, March 31st, and December 5th, 2015. These photographs fairly and accurately represent the conditions I observed. I would like to enter these into evidence as Charlotte County Composite Exhibit Number 1.
Will be so marked and admitted. Please proceed.
Notice of violation was served in accordance with Florida Statute 162. Again, I have had contact with the owner on that one occasion by phone. On December 5th, I conducted my final inspection, and the violations of junk-like conditions and expired permits still exist. This concludes my testimony.
All right. If the county doesn't have anything further, its recommendation, please.
The county recommends respondent be found in violation of the code section listed in the notice of violation, and from the date of this order, 5-year cease and desist order for any future zoning violations, and 15 days to clear the zoning violations, or thereafter face a fine of $50 per day for each day a violation exists. Abatement in the event of noncompliance, and cost of abatement to be added to the fines and costs.
Thank you, Counsel. Charlotte County versus Mike Hester, case COD 16303, pertaining to parcel 22457 Olean, Port Charlotte, Florida. I find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation, and I've adopted the county recommendation as my order. Takes us to case V. Victor, COD 162292, Christopher Turnsky. Hope I got that right. I don't see anyone present on behalf of the respondent. So, I guess Officer LaRue, you're up.
Chris LaRue, Certified Code Enforcement Officer for Charlotte County. 21676 Edgewater Drive is zoned residential single family 3.5. The owner of record is Christopher Turnsky. On July 28, 2016, I conducted an inspection of the property, found junk-like conditions consisting of scrap lumber and a metal electrical box, creating junk-like conditions and a prohibited use. Warning letter was mailed on July 28th and August 17th to the owner outlining the violations. During the investigation, I took photographs on July 28th, September the 8th, and December the 5th. These photographs fairly and accurately represent the conditions I observed. I would like to offer these photographs into evidence as County Composite Exhibit Number 1.
Those have been so marked and admitted.
Notice of violation was served in accordance with Florida Statute 162. I have not had any personal contact with the owner of this property. On December 5th, 2016, I conducted a final inspection, finding the violations still exist. This concludes my testimony.
Thank you. If the county has nothing further, its recommendation, please.
The county recommends respondents be found in violation of the code sections listed in the notice of violation, and from the date of this order, a 2-year cease and desist order for any future zoning violations, and 15 days to clear the zoning violations, or thereafter face a fine of $50 per day for each day a violation exists. Abatement in the event of noncompliance, and cost of abatement to be added to the fines and costs.
Thank you. Charlotte County versus Christopher Turnsky, COD 162292, pertaining to parcel located at 21676 Edgewater Drive, Port Charlotte, Florida. I find that the undisputed evidence establishes the existence of those charges set forth in the notice of violation, and adopted the county recommendation as my order. Agenda item W, COD 162538, Barrett Roadman. I note that no one is present on behalf of the respondent, so please proceed, Officer LaRue.
Chris LaRue, Certified Code Enforcement Officer for Charlotte County. 501 Spruce Street is zoned residential single family 3.5. The owner of record is Barrett Roadman. On August 16, 2016, I conducted an inspection of the Charlotte County permit database, finding permit 2004-093758, for re-roof had expired without final inspections being conducted or passed. Warning letter was mailed on August 16, 2016, and on September 19, 2016, outlining the violations. During the investigation, I took photographs on September 16th, October 12th, and December 5th of 2016. These photographs fairly and accurately represent the conditions I observed. I would like to offer these photographs into evidence as County Composite Exhibit 1.
Okay, those will be so marked and admitted. Please proceed.
Notice of violation was served in accordance with Florida law, or Florida Statute 162. During my investigation, I have not had personal contact with the owner. On December 5th, 2016, I conducted my final inspection, finding the violations still exist. This concludes my testimony.
Thank you. County recommendation, please.
The county recommends respondents be found in violation of the code sections listed in the notice of violation, and from the date of this order, 30 days to renew the expired permit and pass all inspections in accordance with the Florida Building Code, or thereafter face a fine of $50 per day for each day a violation exists.
Thank you. Charlotte County versus Barrett Roadman, COD 162538, pertaining to parcel 501 Spruce Street, Port Charlotte, Florida. Find that the undisputed evidence establishes the existence of the violation set forth in the notice of violation, and I've adopted the county recommendation as my order. Case Agenda X, COD 122568, Timothy Thompson. I note that no one is present on behalf of the respondent. So, Mr. Roadhorst, or officer rather, please proceed.
Good morning. My name is Gary Roadhorst, a certified code compliance officer for Charlotte County. Location of violation is 3103 Broadpoint Drive, zoned CG. The owner of record is Timothy Thompson. On September 19, 2012, Officer Charlie Bush conducted an inspection of the property, finding remodel work in the rear of the building without a permit. The owner obtained the permits for the shed, fence, and the demo of the unpermitted addition in February of 2014. Since the original permits were issued, the permits have been renewed multiple times. I conducted an inspection on April 28, 2016, and found the permits were expired. I talked to the owner, who said he would renew the permits and call for the inspections. On October 25, 2016, the renewed permits expired again. I took pictures of the property on April 28th, October 27th, and December 5th, 2016. These photos fairly and accurately reflect the conditions I observed. I would like to offer the photographs and the copies of the permits into evidence as County Composite Exhibit Number 1.
Those have been so marked and admitted. Please proceed.
The notice of violation was sent in accordance with Florida Statute 162. The respondent was given 30 days to come into compliance, reference existing violations. Since the notice of violation was sent on September 4, 2014, the case had 6 continuances to allow the respondent to complete the permitting process. On December 5th, 2016, I conducted a final inspection, finding the permits are still expired and the structures are still in place. And I also verified this morning that the permits are still expired. That concludes my testimony.
What is the county's recommendation?
I'd like to know the county is dismissing Section 3-9-5 Sub B of the Charlotte County Code and Section 105.1 of the Florida Building Code, and the county recommends respondents be found in violation of the code sections listed in the amended notice of violation, and from the date of this order, 30 days to renew the expired permits, pass all inspections in accordance with the Florida Building Code, or obtain a demolition permit and remove the improvements, or thereafter face a fine of $100 per day for each day a violation exists.
Thank you. Charlotte County versus Timothy Thompson, COD 122568, pertaining to the parcel located at 3103 Broadpoint Drive, Punta Gorda, Florida. Find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation, and have adopted the county's recommendation as my order, which takes us to case Z on the agenda, 1625 2557, John Hayma, Life Estate. I note that no one is present on behalf of the respondent, and Officer Roadhorst is ready to go.
My name is Gary Roadhorst, Certified Code Compliance Officer for Charlotte County. Location of the violation is 1298 Waterside Street, Zone RSF 3.5. The owner of record is the John Hayma Life Estate. On August 18, 2016, I conducted an inspection of the property, finding a prohibited outside storage of plastic, wood, carpeting, tarps, and assorted other debris in the driveway and pool areas. The tarps, carpeting, and a bed were being used to partially conceal a generator that was providing power to the residents. I posted the property as being unsafe and advised Brian, who is a resident therein, of the unsafe conditions. On October 4th, 2016, I conducted an inspection, found the generator had been hooked up to the circuit box of the residence. I took photographs of the property on August 18th, October 4th, and December 2nd of 2016. These photos fairly and accurately reflect the conditions I observed. I'd like to offer the photographs into evidence as County Composite Exhibit Number 1.
Okay, those will be so marked and admitted. Good.
The notice of violation was sent in accordance with Florida Statute 162. The respondent was given 10 days to come into compliance, reference the existing violations. On December 2nd, 2016, I conducted a final inspection, finding the generator was still in operation, but had been moved to the pool area. Tarps had been draped around the pool to conceal the generator. The power was still disconnected, according to Florida Power and Light, and water was still disconnected from the property, according to Charlotte County Utilities. The structure is still unsafe and unfit for human occupancy with no power or water, and is a danger to the occupants that were still living there due to the fuels that were being stored dangerously close to an operating generator and the debris in close proximity to the generator and fuel. That concludes my testimony.
Okay, county recommendation, please.
The county recommends respondent be found in violation of the code sections listed in the notice of violation, and from the date of this order, or a 2-year cease and desist order for any future zoning violations, 15 days to clear the zoning violations and cease occupying the dwelling until water and electric utilities are restored, and 30 days to obtain all necessary permits, then pass all inspections and bring the property into compliance with International Property Maintenance Code, or thereafter face a fine of $50 per day for each day a violation exists. Abatement in the event of noncompliance, and costs of abatement to be added to the fines and costs.
Thank you. Charlotte County versus John C. Hayman Life Estate, COD 162557. Pertaining to the parcel located at 1298 Waterside Street, Port Charlotte, Florida. I find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation, and have accepted the county recommendation as my order. Now, according to my agenda, that takes care of everything except we're up to on the new business. All right. That being the case, Article